Under New Hampshire law, an employee who is injured on the job is entitled to workers' compensation benefits. New Hampshire requires employers to have workers' compensation insurance to cover employees in the event of an injury. New Hampshire law states that the injury must be related to your work and have occurred in the course of employment, including while driving from a job site to another job or while running work-related errands. Once an injury is determined to be work-related, the injured worker is entitled to 4 essential benefits. First, the injured worker is entitled to reasonable and necessary medical treatment paid for by the insurance carrier as long as it is related to the work injury. The injured worker, in most cases, has the right to choose their own doctor to treat their work-related injuries and to choose their own pharmacy. However, if the insurance carrier denies paying medical bills, a hearing on the issue would be held at the Labor Department, and it would be determined whether the bill should be paid by the insurance carrier or not. Having an attorney to represent you at a Labor Department hearing is an important choice. The second benefit is weekly disability benefits, also known as indemnity benefits. An injured worker is entitled to 60% of their prior average weekly wage, which is determined by averaging the employee's prior 26 weeks of wages. However, it may be possible to increase this benefit by looking at additional weeks of employment or by considering a second job's income. An injured worker is entitled to disability benefits as long as a medical doctor has provided a New Hampshire workers' compensation disability form. The insurance carrier does have an opportunity to dispute an injured worker's entitlement to disability benefits. Ultimately, the Labor Department resolves any disputes about an injured worker's entitlement to the benefits through the hearing process. Third, if the injury has resulted in a permanent loss or impairment, the injured worker may be entitled to compensation for the loss. This entitlement is determined by an evaluation of the injury once a medical endpoint has been determined by a medical doctor. The insurance carrier can also ask for a separate medical examination. If the parties cannot agree on the permanent loss, again, the Labor Department will determine the extent of any permanent loss after a hearing. The fourth benefit is the assistance of vocational services. If the injured worker is unable to return to their past work because of the injury, the insurance carrier usually hires a vocational specialist to work with the injured worker. The goal is to return the worker to employment within their capacity at a wage that equals or nearly equals the prior average weekly wage. In most cases, this benefit lasts no longer than 1 year. You may need an attorney who is experienced in workers' compensation law to assist you in your claim. There are numerous deadlines and countless rules and regulations that require you, your employer, your doctor, and the workers' compensation carrier to take certain actions. The insurance carriers have access to experienced and knowledgeable lawyers to work for them and to protect their interest, and it is important that you do the same. At Manning & Zimmerman, we are committed to fighting for the rights of our clients. We never defend insurance companies. We only represent the injured. The insurance company handling your case will have its own attorney. Shouldn't you have your own attorney as well? Please visit our website at manningzimmermanlaw.com or feel free to call us at 603-624-0000.